Christina Stifler on behalf of the state. We're here on number 1, Mario Fernandez Saldana, number 2, Shanna Gardner.
Thank you. Morning.
Good morning, Your Honor. My name is Jesse Dreiser, here with Shannon Day and James Hill and our client, Mr. Fernandez, who's present. How are you?
Good morning.
Good morning, Your Honor. Jose Baez. I have Michelle Medina, Professor Sullivan, Diane Menashe on behalf of Shanna Gardner.
All right, thank you. And Mr. Dreiser, I don't know if you, Mr. Tassoni is also on.
Oh, I didn't.
Yes, he's on.
And Frank Tassoni as well. Thank you, Your Honor.
Thank you. All right, so we are here for a pretrial.
Yes, ma'am. Some updates.
Okay,
We took depositions last week. Been taking depositions. We're in the process of setting more depositions. There are 3 defense teams and a multitude of lawyers. I've provided multiple dates and I've asked for advance notice so that I can secure some of these witnesses are care of the state and some are federal agents, which require 2 letters. Ms. Day and I are working on a joint coordinated schedule with everybody. They've provided me this morning depo dates. We have some this Thursday, April 10th, April 13th, April 16th, and then I provided a counter date for one of the witnesses the week of April 20th.
who are the federal agents?
ATF agents, Secret Service agents, FBI cast analyst.
And those are outside of the agents that have already,
Yeah. Well, you've heard about the cast analyst before.
no, I thought one of the Secret Service and ATF were,
We did ATF last week.
Yeah, the
We
Secret
did.
Service agent appeared on Thursday. The deposition of the ATF analyst went long, so defense counsel
Okay.
excused him. And we're going to reset him.
how is the 2E process working?
I've been handling it. It's been fine. Everyone's been willing to appear.
So, like timing wise,
The ATF, as long as they give me sufficient notice, at least 2 weeks for some of these depositions, but they've been turning them around on our request in a couple days.
okay, great.
We're
They-
hopeful to be done with all of the depositions from the Fernandez team within June. I think we're really nearing the end.
Okay. And so, let me address also, the defense team for Ms. Gardner. She is obviously not present and that's by request of parties, correct?
That is correct, Your Honor.
Okay,
I
and,
mean, we just didn't, since we're not present, we figured we could
right,
just
it
have
doesn't make
this.
any sense.
Correct.
From your perspective, Mr. Dreiser said his anticipated completion of the depositions. Do you all agree?
Yes, ma'am.
Okay. June.
I'll discuss with defense counsel, or I'd like to get a schedule through June if we can. And then obviously the state has, I won't say concerns, but the state does need sufficient time to prepare post their discovery depositions ending. So I think June is reasonable and agreeable to the state. If it looks like we're not going to get there, I may ask for a court deposition schedule to be some kind of deposition schedule like they do in civil practice to be filed with the court. Just so I'm making sure these witnesses are they can be there. We're not excusing people or missing depositions because they don't have sufficient notice. And I'm happy to coordinate, and I'm not saying anything against defense. We've been coordinating with Ms. Day. Well, I just have concerns. The state wants adequate time to prepare, potentially asking for a deposition deadline sometime in mid-June.
Well, I don't want to put you all in a crunch. So I'm logistically speaking. So it's April, let's say. I want to give you all sufficient time so that we can kind of use July for getting any motions or whatever heard, or I don't want to run y'all right up against a trial date. So what do y'all think?
I think depositions are moving slower than anticipated. The length, I think we just need to get together and be more realistic about the amount of time we're setting per witness. And I just need more time.
Well,
more
well,
notice
now
of
we
what
just
they're gonna
need,
propose.
how does Tenon factor in?
He's no longer a state witness.
No, I mean, as far as the
Oh, Ms. Schlax,
discovery.
Ms. Schlax is coordinating with defense and participating in depositions.
Absolutely. But it's a great question because it's another cat that we have to herd in this scheduling issue. So it has been a little slower. I think from the defense team, I would say we've been machines in depositions. We've been thorough in depositions. They may have gone longer. There's now a new lawyer asking lots of different questions on behalf of her client. So it may have slowed down, but for obvious reasons. There's a new defendant in the case.
I need y'all to stop talking kind of in generalities. Give me practically what is occurring. Because in my mind, Gardner and Fernandez are set in stone. We are going to try this case. And so it is, the rules say reasonable coordination efforts. And if Ms. Schlax is, because she's coming in kind of back end, I think there needs to be, because of the circumstances, you all need to do reasonable scheduling efforts, and then maybe these witnesses she orders and then ask additional questions if she can't make it. Because these, I can't have someone who is not set for trial slowing down cases that are set for trial, charged in the same indictment, going to be like, I can't have that occurring. And so that's why I'm saying, don't talk in generalities, talk real with me, meaning I want to know, operate on the rules say reasonable. If she can't make these, then
Right,
okay.
It's not her fault. Like,
I'm not saying it's her fault, but I'm saying that this has already been set.
understood.
So that's what I mean. So if it needs to be a concession on the state, my understanding is you're not seeking to try him with them, correct?
Yes, ma'am.
So that means y'all operate, okay? Y'all operate on the trial date
are-
with those deadlines.
There are witnesses that are not going to be witnesses against Mr. Tenon that we can set depots for, that Ms. Schlax probably, in my conversations with her, would not participate in.
Okay,
There are some witnesses that do not overlap all three defendants.
okay. Well, I'm just relying on y'all. Like, I don't want that to like slow things down, if that makes any sense. And I don't, unless y'all are telling me exactly what's happening, I really can't comment any further than that. But my intention is I want y'all done sooner rather than later, because there's a lot of litigation. The state asked for May for hearing time. And so my thought was that y'all would be finished, like, hopefully near the end of April, and then we use May to litigate. I leave y'all alone essentially until we need logistical things. And so if the addition of Tenon as a defendant and his defense team, in my mind, it just, y'all have to operate with the schedule that we have, because there's too much at stake.
Probably a good time for us to address either today that we're going to address it at some point soon, but trial schedule, not necessarily when it's starting, but who's going to be tried, seems to have shifted amongst the parties. I don't know how much.
What does that mean?
Is aware. It's by agreement, my understanding that the state and defense, Mr. Gardner prefers to try our case first and separately. So it would be, we would go jury selection and our trial, which we anticipate we could be done within 2 weeks. Then Ms. Gardner's trial would go next, and then Tenon, obviously, not my concern, would not factor into that. But they no longer intend on trying these cases together, and that's by agreement by all parties.
Okay. When was somebody going to let me know?
Well, we asked for a logistics meeting with the court, and I believe it didn't work out because of defense schedules. But Mr. Mizrahi and I think, discussed it a little bit with Your Honor at sidebar. We can certainly have further discussions.
I didn't understand it that way.
Alan was trying to get plan is to pick out the same panel and swear both juries at the same time. That's why I like Your Honor, you know, about the parties. Mr. Dreiser's in agreement with that plan. I'm not so sure the fraud are in agreement with that thing. Not that they have the ability to object to it. They may.
I'm sorry, can Mr. Mizrahi speak in the microphone?
Can you talk in the microphone because they can't hear you?
I'll speak into the microphone. The plan is to, of course, is to pick out of one jury panel, swear both juries, and then proceed with the Fernandez trial until its completion, and then begin the Gardner trial with its sworn jury immediately afterwards. Therefore, we can try both of them together. Just would be we have two separate juries anyway. That was always the plan. The only real difference is we were going to have both juries in the courtroom for certain witnesses. Based on Mr. Tenon's withdrawal of his plea, that main witness that is not going to be present. Juries together, since there are numerous witnesses where the two juries will be separate anyway. More witnesses separate, or at least comparable witnesses separate than would be together. And the number of witnesses that would be in front of two juries would be mostly professional and ministerial in nature. So that's the state's proposal. Yeah, so everything, nothing changes in terms of the dates we have blocked off or anything.
Yes, it does. I mean, Mr. Dreiser just said it would take 2 weeks to try Fernandez. And then Gardner, I'm assuming they would need the 2 weeks too.
I was including jury selection.
Right, I don't think it's going to take 2 weeks to try Mr. Fernandez.
Yeah, it won't, I agree with that.
The timeframe, Your Honor, is going to be virtually identical. There may be, obviously, there'll be certain witnesses that we would only do one direct on as opposed to two directs on that we'll have to do. So that timing of the witnesses that we do two directs on, that's, you're talking about several hours difference in the two trials. Everything else is the same. The crosses will be the same, the openings and closings will be the same, and the shuttling of juries is incredibly difficult logistically.
And timely. I think to cut into the 2 hours that you just talked about, you could subtract time for the shuffling and objections and whatnot. So I bet it's a net 0.
Mr. Baez,
Yes, ma'am.
what are your thoughts while I'm looking?
Our position is we're in agreement with separate trials. However, we would like to, rather than picking the juries at the same time and then having the Gardner jury wait and perhaps create a whole slew of issues, we would like to go immediately following the Fernandez trial. We could then pick the jury right then and there and proceed like a normal trial. It eliminates so many logistical issues as well as potential appellate issues. It's just a lot cleaner that way. And I agree with everyone else. The time frame is going to be the same. We just think that it would be much cleaner to do them back to back immediately, one following the other immediately thereafter.
And Your Honor, the state disagrees with that. The time frame is completely different if you have two different jury selections. That's completely moves the time frame several days probably.
Well, I'm listening. I'm listening to both sides. So what we had initially planned was jury selection happening concurrently, trial concurrently, closing down one. And I was asking the state, duplicate as much as you can so that then when verdict is reached, I could seal and then close down the other, then bring them both, summon both, publish at the same time. And so my thought is that if you all agree, what really should happen per the rule is Rule 3.152, and it says, and it's 3.152B. It says on the motion of the state or the defendant, the court shall order a severance and separate trials. Okay, so it needs to be by motion, not agreement, because what has brought them together is a joint indictment. And so if you all want separate trials, it needs to be by motion. And then once that occurs, I think we need to adjust the time frame. I would be nervous and concerned for everything that Mr. Bias just said, which is you go send a jury home. There's been great media interest in this case for them to sit down. And so whatever jury you would have picked for Ms. Gardner, you would have, in my mind, you would have to pick, 10 alternates, so that just in case you'd picked. And so to me, it doesn't do anything. So I would be willing to call in a special jury selection process for Ms. Gardner, maybe on a different day than we normally would. You know what I mean? If you all talk to me about the scheduling, like when you believe that Mr. Fernandez's case would be almost concluded.
Your Honor, that is, in the state's mind, it's an illogical process. The reason to try these cases together is in large part for judicial economy.
Agreed.
Separate juries, it completely eliminates that positive aspect of doing it, of picking one. There's a couple things. One, if you pick one jury, both juries at the same time out of one panel, all that media attention, all those questionings, all this preliminary stuff that we're going to be doing is going to be done once, not twice. Once the Gardner jury is sworn, I agree, we'll pick more alternates for her case. They will be instructed to avoid media contact. Some won't. But we'll pick more juries than we normally would because they have a longer break before they're seated. If we pick their jury immediately after, the panel that's going to be coming in is going to be filled with people watching the media for the 2-week Fernandez trial.
Agreed. That's why I don't know why this is even a question to me. I understand maybe some of the witnesses don't overlap. To me, those are order of proof issues, meaning that you group the ones together with the thought that that jury would sit out as little as possible. You pick both juries, but if you pick Miss Gardner's jury, it is just, to me, filled with potential of error and of exposure. And you can say, come back next week, and then we'd be through another jury selection. And I'm sure the state wouldn't want me to swear them.
Absolutely, we'd want you to swear them.
You want me to swear them?
Yes, absolutely.
Okay. And then, we run through the jurors and potentially lose some of them or all of them, and I'd have a mistrial potentially, and then we'd have to start this whole process all over again.
You have a mistrial in any case, at any time.
No, but you're building in a situation where it would almost, we're just asking, it's like Pandora's box. Don't open it. Don't open it. And they're presumed to follow the court's instruction. Logistically, I don't really see, if we know that jury selection would take 3 days, but, and how long are y'all anticipating Mr. Fernandez's case to go?
I believe the state has told me they believe less than 5 days, 3 days or 5 days for their case in chief.
I think a week and a half is very, very conservative and safe for the completion of the Fernandez trial post jury selection. And I think it's more likely a week, but with a couple more days after.
And I've said 3 days for the defense before. I'm now comfortable saying 2 days, and that's conservative. That's giving me time that if my client chose to testify, I'm building that in. Whatever experts we know that we're going to call, I'm building that in. And we're close enough now that I'm pretty comfortable as to who we're calling and what that would look like.
So you're saying 2 days for the defense case?
I would imagine that's enough time.
Okay. With your scenario, Mr. Mizrahi, what do we do if Mr. Fernandez's case goes over? Just keep the jury.
If we were trying them together, we would tell the other jury to come back on a different day, because the plan would be for them to come back, let's just say, for example, on the 2-week Wednesday, so you'd have a full week of Fernandez's trial. They would come back the next Wednesday. If we're bleeding into that Wednesday, you would tell them to come back on the Thursday. You would tell them to come back on the Friday, wherever the case may be. They would be sworn and told not to watch any media. It's the same as if we were doing the trial together. This trial with 2 juries is going to take a very long time. These jurors.
It's not the same.
It's
I like it.
slightly longer, I
No,
concur with that.
disagree. It is not the same because what we discussed is that you pick the juries at the same time. They're reporting in potentially like having different, for example, hypothetically, okay? So logistically, Mr. Fernandez is the A defendant. You all would give opening statement. And so the state, generally speaking, when you're trying two defendants at the same time, you give one opening statement, you ask one jury, if you're talking about things that are not admissible in front of the other jury, you say, may I have a moment? You send that jury out, then you finish your opening statement. Defendant A gives his opening in front of A and B. Defendant B gives their opening statement, A and B. And then you all start your case. All of the jurors sit in there almost concurrently working as much at the same time as possible. Generally speaking, some witnesses, they go out, you give them a longer break, but they're working the whole time. Everybody's working. Maybe a break with Mr. Fernandez, maybe a break with Miss Gardner's jury, but they're all working. It is not, hey, I've got this case. It's not going to be a secret that it has attention. And so you're going to pick 2 juries. I'm going to tell them, don't watch the media. But then I have no way to really ensure that / protect them. I was going through specific steps to protect them. They were going to be sequestered when they are not working. Okay, so they have added protection. But if I'm a follower of the rules. So if this is the way that y'all want to do it, I'll just extend the time frame. And I'm not gonna put myself or the jurors in a situation where if one case goes over, and I know that y'all, we all have great expectations that we can finish things very quickly, but the reality is there has been no hearing in this case. There has been no proceeding that has ever been short. I mean, it's never been short. So, I mean, that's a reality. We all have expectations or hopes, but the reality of this is there has not even been a hearing. I think there's been less than 30 minutes. So, I mean, if that's how y'all want to do it, I'm going to rewire it, and then I'm going to get with the clerk's office, and you all, if they're severed, they're severed.
Right, with the state who's not in agreement with that, the parties haven't reached an agreement, so we're just gonna have to, at this point, we're in the exact same posture that we were before.
What do you mean?
Because Mr. Baez's team does not agree with this.
No, he said he does agree.
He does not agree. He wants to do a completely separate jury selection. He does not agree. We're not agreeing.
Okay.
We got it.
Mm-hmm.
What rule? I mean, so you're not asking to sever, you're just asking to try them separately. That doesn't make any sense.
Wait, we are picking, I've done this in multiple occasions. We are picking out of the same panel. We are swearing both juries. That's the only thing that's going to be together. So I mean, that's a partial severance.
So you've done a concurrent trial where you've picked 2 juries and sent a jury home for 2 weeks and tell them to come back.
It was a week. It wasn't 2 weeks. It was
Well, this will be 2 weeks. I mean, let's be real.
I've done it where I've picked 2 juries, sent one jury home for a week, and then
Okay, what case?
the Alan Wade and Tiffany Cole.
Okay.
And Your Honor, if I may, Diane Menashe on behalf of Shanna Gardner. I talked about this issue with the prosecution when I was in town last week about if they're severed, then they're completely severed, right? Separate jury selections, et cetera. Although we could certainly go, we would be willing to go immediately after the Fernandez trial is over. I would also say when the prosecution has said that they've done this before, this case is different. This will obviously be nationally televised. We're not talking about just media or print exposure. I mean, potential jurors, you know, they can be told not to look or watch TV, but this is the case, as we know, even participating today is the Law&Crime Network. The trial will be live streamed, and by the state's own admission, there will be evidence, witness testimony, physical evidence, et cetera, that will be introduced in the Fernandez case that will not be introduced in the Gardner case. So I would submit that if there isn't any precedent for that type of sort of jury selection and then holding a jury back in a prior case, that it's apples to oranges.
We'll say that in terms of inadmissible evidence in the party, it's really the reverse is true. Although there may be a small piece of evidence that's not admissible in the Gardner case, it's admissible in the Fernandez case. It's really the reverse. It's the vast majority of the Gardner case is inadmissible in the Fernandez case. So I'm not as concerned with that particular issue. I mean, I'm trying to save time. The cases are now joined. Defense objects. We can always just keep going the same plan that we were always going. I was trying to make these things efficient and easier for everyone to go, because what I can inform the court of is this is not a case in a situation where we're going to be able to shuffle a jury out for a witness or shuffle a jury out for part of our opening. The core of the Gardner case is inadmissible in the Fernandez case. So you are talking about at least a half a dozen witnesses, if not more, that are not, it's just not admissible, probably more than 8 to 10 witnesses that are not admissible in the Fernandez case in their totality because they contain statements that Ms. Gardner has made. So the openings are not like we're going to send one jury out and say, oh, by the way, here's 2 lines. I mean, it's integral to our entire case. The reason they were that we charged them together is obviously they're co-defendants, and as well as when Mr. Tenon was testifying, there was a logistical reason to keep them together because he was a testifying witness in both. Without him, it becomes less of a priority for the state to keep them together. But that's the way it is, and no one's made a motion now, so we can deal with it when we have a motion.
Judge,
Go ahead, Mr. Bias.
no, I was going to say, both of these trials are really only 2 weeks. We've all tried cases 6 weeks long, just one case. And for this to be such an issue when we're really looking at just 2 weeks, given the complexity of the case and what's admissible and the witnesses as described just now by Mr. Mizrahi, not to mention the potential issues that could arise, appellate issues, it's just far too important. And we're really not talking about that much time. 2 weeks, that's nothing. I welcome a case like that. I expected this case originally to be somewhere along 6 to 7 weeks long. 2 weeks seems like a major cut in what we were expecting to begin with.
So can I weigh in just a little bit? Okay. First of all, this motion, I don't necessarily think that there is a motion, okay, but because the state's asking, I guess, to try them together, but just in a different way. And so if the defense wants me to consider a total severance, and I agree, like it is one thing or it is the other thing. You can't have your foot in both camps. So it has to either operate as a complete severance. But what I will say is if the reason why, Mr. Mizrahi, I have concern. I'm not making any rulings, but I do have a concern. And I think that you should maybe take a little bit of input. If I logistically go the way that you are suggesting, okay, meaning the scheduling of this, you're saying it saves time. That's up for debate. But however, in the case for Ms. Gardner, to me, there is a lot of potential for prejudice. So let's say we do your time-saving jury selection, you do your trials, okay? I would think that there would almost have to be kind of a reinstitution, or I would have to allow the parties for the state and the defense to ask questions of those jurors to make sure that they did not get any type of exposure before I just sat them and had them try the case under like extraordinary media coverage. And so like you would want them sworn, I have to bring them out. I would do that. So like to ensure that her jury, if sent home for a week, 2 weeks or whatever, was not somehow impacted. I think that that's worth it. So if the state thinks logistically, I'm going to leave it to the parties and then I'll consider whatever motion y'all want. But I think this being a time saving, I don't know if it necessarily is or isn't, because I wouldn't be able, if Miss Gardner's case came forward, I'd have to have some type of separate proceeding with her lawyers in the state and allowing that jury to be questioned at least to make sure that they didn't see something that's going to be live streamed or whatever. And I'm looking at the case that you cited, which is Allen Wade, which was a death penalty case. And I'm looking at it. It looks like the jury was selected, it looks like in a day and a half. And things have changed quite a bit since 2007. And how, like, I know that was an extraordinary media coverage case, but it wasn't, it didn't have the level of time. And so I understand saving time on jury selection. I have no idea how the state or how many witnesses overlap with one another. But that's why I was saying, like, I think that if thought was put into it, that you could put it in a situation where the juries aren't out for as long as a week or 2 weeks. Maybe they're out an hour, an afternoon, or a day, and then you put on the witnesses and then have them report the second day. There's not that lag between, but it's not before me. You all talk. But I do need, if y'all are going to change things from what we were initially discussing, that has a lot of implications. I was making a big ask of this circuit and the resources that we have to ensure that those jurors were taken and not exposed. And so if y'all are going to change things, I need sooner rather than later. And I mean, not out of April, because it takes a lot of money from the stakeholders and logistical plans. So that, Mr. Bias, that's why it is a big deal to me, because like there were dollars that were asked for. There's things that I was putting into place based on our prior discussion. If y'all are gonna change the landscape, I need to, it doesn't matter to me. I have time to do it, but we need to do it sooner rather than later. So
It's a priority from the Fernandez team because it affects the strategy of the case entirely. So we will either make an agreement with the state or file our own motion to be heard on this
okay,
very quickly.
I need it.
Yeah,
Because
I
they're already doing things. The clerk's office is already working on the summons and how we were talking about doing this whole thing. So it can't just be a conversation. It needs to be like a meeting with everyone that was working kind of to make this happen and make it easy for the attorneys and the parties. Okay?
and we'll address it at the right time, but I have to say, not that Mr. Fernandez's case doesn't have media attention, it does, but I am convinced that our jury selection is entirely different than Miss Gardner's jury selection. I believe the way the media covered Ms. Gardner versus Mr. Fernandez, the level of interest, the number of blogs, the family of the Gardners, international being well known, and respectfully to Mr. Baez, I cannot imagine, and Ms. Menashe and the team of lawyers that they have, that does not factor in to jury selection, given the high-profile cases that he's had in Florida and the media attention. Respectfully, no one knows who I am or my team, and that won't be a feature of jury selection as it's never been. So I do think there are significant differences that need to be taken into consideration as well.
So, I mean, tell me what you're saying. I don't, I mean, like you're saying that
I'm saying that
as far as the
know
meet,
who Mr. Baez is, I'm sure that's going to be
Okay.
a factor of jury selection. People saying, I know.
but tell me what that means.
That
is
means
what
that my jury selection, I don't anticipate being all that complicated, just like a normal murder trial that we've all tried before, with some level of, oh, I've heard about that case. I don't know that even when people know about the case, they know necessarily as much about Mr. Fernandez as some of the others involved. That's what I'm saying.
Okay. All right, I understand what you're saying now. So you think that the jury selection could be somewhat faster?
Mine versus Ms. Gardner's, yes, I think will be fast.
Okay.
I agree with that. I think it will be faster.
So why wouldn't that weigh into like doing them separately, like totally separately?
Why don't we talk about it and see if we can come to an agreement?
It will take, the duplication of directs by the state is what we would be wasting time with by separating these cases, and the duplication of directs, in other words, we'd have to do a direct examination of the responding officer twice as opposed to once. Everything else is the same, right? So the duplication of jury selection in this case exponentially longer than the duplication of direct examinations. The duplication of direct examinations is several hours. The duplication of jury selection is several days. That's the difference.
All right.
But
And then
I have no motions. So
lastly, Judge, we filed a motion to suppress. I think
Okay.
likely the only evidentiary motion that the defense will file from outside of motions and limit, the more closer to trial type motions. That's what you asked for. You set aside time for. It's probably a 2-hour hearing, I guess.
I had time to review the motion. It's pretty straightforward from the state's point of view. I don't know necessarily if I'll need a witness or just introduction of evidence, but I would probably say 3 hours just to be safe.
Good call.
And we have motion hearing time set aside the week of May 4th, the week of May 11th. I set one for Mr. Tenon the week of May 11th, which is also quite short. I'm anticipating getting suppression motion from Ms. Gardner's team, as Mr. Carody said, on the T3 wire. So that one might be a little lengthier, and I'll defer to Mr. Dreiser if he wants to set this to be set May 11th. We could do this motion
Well,
one day, Ms. Schlack's motion another day that week.
let me ask, I know y'all are busy, okay? Are there dates that you want me, I can just block them off, like instead of like a to be set, like if I had a trial and make it work, I can block dates because of y'all's schedules.
Sure, we can do that. I haven't had a chance to talk to them yet, but that would be, I think, fairly easy. And I'll speak with Ms. Schlacks as well and get the court dates for those two defendants' motion hearings.
Can I,
Is
Wednesday the 13th?
That's fine. That's fine with the state.
Okay. I think Ms. Schlack said something about a trial
She's
or,
got a capital case that concludes the week of May 4th. So Mr. Tenon's is to be set forth, understanding it will be set the week of May 11th. Hers is quite short, so we could set hers that 14th or 15th when she'll be out of trial. I'll get with her and we can email Ms. Wilkes some dates. Or leave it on as a to be set on the 4th.
I don't want to do that. I want to block the dates off and then just give y'all as much time as you need. Can I circle back to the motion, non-motion that was brought up?
Ma'am.
Do y'all think you can have a decision made by next week?
I think if Ms. Gardner's team, it can coordinate with us for a Zoom meeting, then yes.
Yes, I absolutely we can.
Well, we'll have a better idea if we have an agreement or not. If we do have an agreement, I doubt we'll have the details hammered out by next week.
I don't need details, but I do need like what you all are at least like, because when did we initially meet? January? When was that meeting?
January.
Okay. So, and we are 5 months out, so that would not stress many people if we could have something. And then we'll be 4 months out. That's doable in my mind. So if we do need to pivot and do something different, that's fine. But and if it can't be settled, that's what I'm here for. So, I mean, y'all know the case. I don't. I'm just trying to make sure that there's enough time reserved. I have no clue. So the only thing I'm asking for you all to consider is not hope, but reality of this case. And then like, meaning how long things just generally take. These are not issues that are generally, they're unique. Let me look real quick.
My recollection is you blocked off 8 weeks. Is that right?
No. No. So I changed it. I had, we were picking, this was the initial plan. So I'm going to send y'all off to have fruitful discussions. Okay. August 10th through August 14th, that whole week. My hope was that everyone said that y'all think that it wouldn't take that long. So I said, regardless, let's say y'all finish on the Wednesday or y'all finish on the Thursday, I would still be out of session. The jury would be picked. Y'all can work. I'm trying to give y'all time to work. Okay. That after the jury selection, y'all have built-in time. Okay. We would start the trial, I thought both trials, August 17th through the 21st, working full days. And when I say full days, I mean 9 a.m. to like 5:30 p.m. No calendars, no nothing. If I did have something, I'd meet with them way early. Then the full week of August 24th through the 28th. And y'all said you would be done, I thought, like midweek that week. And so I was using the 27th to close down Fernandez, 28th to close down Miss Gardner's case. I was going to seal the first verdict, close down the second case, and then once Miss Gardner's case had their jury reach the verdict, I would summon both juries back. Mr. Fernandez's case would only be sequestered for the night or the time frame that it took Miss Gardner's case to get closed down and verdict. Then this is what I'm saying. They were sequestered. They were just, after their work was done, they're going to a hotel room for a very uninteresting vacation, okay, for a day. And then they get brought back to publish, to pull. That was my thought. And so I did not, those are 3 weeks. So
We had
That's pretty-
first week of September, blocked off as well.
I didn't have that.
All of that.
I didn't have that.
Well, sorry, Mike.
Mr. Hathaway?
Your Honor, I don't have it on the official schedule.
So,
Well, there's been,
I don't,
in fairness, there's been sidebars, there's been.
right, but I'm just telling you, well, Mr. Hathaway matters. Okay,
Yeah.
so like if it's not on the court schedule, I didn't have it. I have other cases set for trial that week. And so that is what we had 3 weeks, 2 weeks set aside for the trial. Y'all might have had the third, that other week because there was a potential penalty. Once that went away, that went away.
I think when we had potential penalty phases, we blocked off almost 8 weeks.
Right. Well, the schedule has been posted on
We're
the
gonna get-
docket.
As you instructed, we're going to get this resolved by agreement or by motion, and we're going to do it within days. Okay?
Great.
And then
I'll see y'all next week.
Lastly, from the defense, Your Honor, we had spoke about giving me an opportunity in another courtroom today to be alone with Mr. Fernandez. I don't know if you recall that.
Yeah.
Can we get that logistic
Yes, sir.
put away
Yes, sir.
today?
Yes, sir.
Thank you.
Your Honor, if I may, if we had a penalty phase necessary, we did cordon off through 9/18.
But that went away. So I'll see y'all next week and we'll talk logistics, okay?
Okay.
I'm back on Thursday.
The ninth is fine. We have depositions set April 10th, so.
Thursday.
The 9th is not good for me.
Yes, sir.
Um,
When are you available?
Anytime before the 9th?
I'm out.
Are you back? We could do it early in the morning on the 9th, if that works.
What about Friday
What's Friday? The 10th?
this week?
Oh, this week?
Yes.
Yeah, I can.
Courthouse is closed this Friday.
Oh, it is. That's why I have Friday.
Ah.
Um,
What time on the 9th were you thinking?
We can be here at 8:30 if that is easier for Mr. Baez. That's agreeable.
It doesn't have to be 9 a.m. on
I'm
On the
an
9th.
early bird, so if you want
8:30 is
8:30,
fine. Yeah,
okay, 8:30.
8:30 is fine. 8:30 works.
Deal then.
Okay, see you then.
8:30.
Perfect. Thank you. Have a good day, everybody.
Thank you.
Take care.
Mr.